Okay, I think I've said everything I've had to say. Mr. Calvano, you go ahead and announce yourself and give me an opening statement on this one.
Thank you, Your Honor. Corey Calvano for the Attorney General's Office. Judge, this case was originally filed as an original petition and suit affecting the parent-child relationship based off of an acknowledgement of paternity on April 18th, 2024. There was a citation that was filed with the court. It was a citation signed by Sheriff's Deputy K. Bammett, number 331, that it was a sworn affidavit citation filed with the court that Mr. Gonzalez was personally served with the papers on the 10th day of June, 2024 at 9:30 a.m. at his residence of address. Thereafter, Mr. Gonzalez was defaulted on August 2nd, 2024 in an order in suit affecting the parent-child relationship. And by the end of August, let me pull up the exact date, my apologies. It looks like the final stamp. The 23rd day of August 2024, Mr. Juan Gonzalez filed a motion to set aside the default judgment in this case. I believe that the statements in the default judgment claim that Mr. Gonzalez was not given enough time to prepare and that he was improperly served citation. And Mr. Gonzalez is asking that the order be set aside.
Okay, then I'll have to have a hearing on that. I assume it's opposed. So this court is for.
Yes, Judge. I do believe that Ms. Rodriguez opposes the motion, as does the state of Texas. We believe that the citation is properly filled out and valid. And that the order, the default was appropriate at the time. Also, the state of Texas is in its belief that the likely outcome, even if the order is set aside on essentially a new trial, would be substantially the same as it is now, but that can all be heard through testimony.
Okay, then we'll go for it. The state's going to call both of you as a witness one at a time. They get to pick who goes first. Well, actually, it's Mr. Gonzalez's motion, but it might be efficient if the state calls witnesses. Is that what I'm trying to say?
I think that would be the best course, Judge. Yes.
Okay. Yeah, I would agree with that. So whoever goes first, the other person needs to remain silent. It's not your turn. You don't get to interrupt testimony. If you have a valid legal objection, that's one thing, but not just to tell your side when the other side's talking, and you'll be given the same courtesy. So one at a time. Everybody talking at the same time doesn't work for me, and it won't work for my recorder, so I would stop you anyway. So just be courteous of that. Mr. Calvano, you may call your first witness.
Thank you. Then I'll call Juan Gonzalez. Mr. Gonzalez, you filed a motion to set aside this default judgment, and in the motion, I'm first going to address the citation and the claim that the citation is invalid. So, Your Honor, may I screen share the citation?
Yeah, I'd like to look at it myself too. Let me see if it works, or do I need to change my settings on my side?
Yes. Currently, it needs to be changed, correct, Judge?
Okay, that'll be easy. There you go.
And okay, the citation should be up and apparent for everybody to see. And for the purpose of the recorder that is taking the testimony, I'll explain what the document is. This is an original, it's stamped original, and it's a citation, and the name on the citation is Juan Jose Gonzalez Jr. It's filed for record on June 11th, 2024. The citation goes on to say that What was served was the original petition and suit affecting the parent-child relationship and the notice of court proceeding virtual. And it says a default judgment may be taken against you. Thereafter, it has the date that the citation was issued by the court. And I don't know why that blue thing is there. The process was received by the sheriff or constable on the 30th of May, 2024. The box checked that is checked that the sheriff served a true copy of this process endorsed with the date of delivery together with an original petition, suit affecting the parent-child relationship, and notice of court proceeding on Juan Jose Gonzalez in person, and then the address of where it was done. And the date of 10 June 2024 at 9:30 a.m. is written in there. And then the sheriff's stamp, Deputy K. Bammert, number 331, is stamped on the citation. So, Mr. Gonzalez, in seeing the citation, can you tell the court why you believe this citation is faulty?
Okay, because I was never served. I never made contact with the sheriff. The sheriff he never made contact with me with this citation. I have the citation right here in front of me also, and that whole bottom part, the very bottom part, is not filled out on my copy. All of that part right there, none of it is filled out. Like I said, I never made contact with him at all. Never.
Okay, Mr. Gonzalez, it's not that I don't believe you, but the citation is presumed to be correct. And when you bring a motion to set aside, the burden shifts to you to then prove that the citation is incorrect or faulty for some reason. So is there anything other than your testimony that can help you prove that this citation is incorrect?
There is not.
Well,
And if
go ahead, Mr. Galvano, finish up.
If I told you that the common practice is that the sheriff fills out the bottom of the citation after he served the papers and prior to delivering the papers to the court to be filed, would that surprise you in any way?
It wouldn't. No. But it's still go ahead.
No, it's okay. You're welcome to tell your story. This is your motion.
No, I'm just letting you know. I'm just telling you. He never made contact with me, and it said it was like at 9:30 in the morning.
It says 9:30 a.m. Correct.
Nah, he would have never made contact with me because I would have been asleep, even at that time because I work overnights, so I would have been asleep. I mean,
then let me just jump in with a bottom line question. How did you get a copy of all that stuff if it wasn't handed to you?
This citation was just rolled up on my doorstep, rolled up in a rubber band. Yes.
And when is it that you
I do not remember, and I can't recall.
Okay, let me finish asking the question. Okay. When is it that you believe that you first saw the citation?
Like I said, I really can't remember. I just know it was sometime in July. In the sometime mid-July, probably.
Okay, so if the sheriff left the citation on your doorstep on the 10th of June, what you're saying to the court is you didn't see it until sometime in July.
I couldn't really tell you. I do not know, but it was sometime in July. I said, yes.
Okay,
I really don't remember. I can't remember.
That's fine. And just so you know, the judge didn't hear what we discussed earlier, so I need you to, it seems like you're repeating things because you are, because the judge needs to hear them now.
All right, sir. Yeah.
So why is it that the citation might have sat on your doorstep for such a long time before you saw it?
This whole summer, I've been back and forth in San Antonio. I wasn't even at my house most of the time. A lot of the time, I was in San Antonio, so it could have been sitting there for a few days. Who knows? Before I even found it.
Okay.
But honestly, like I said, I have no clue of what day. I didn't make note of it when I found it, when I picked it up. It was just left at my doorstep, rolled up. I didn't even think to write down, the date or this or anything. So, I mean, I have a lot of stuff going on in my life right now. My mind wasn't there to make a note of it. I didn't think it was, going to be a really big issue. And I didn't even know I wasn't served correctly until not too long ago either. So.
Okay, and what made you think that you weren't? What prompted you to think that you weren't served correctly?
Just with the whole court thing going on, and I was just curious, just going over everything, and I was like, well, it's a citation, aren't I supposed to be served this? I was getting other people's advice, and they were telling me, yes, you were supposed to be served, and I told them it was just left on my doorstep, rolled up, on my doorstep, and I found it there one day, and people were telling me no, that's not the correct way to be served. It has to either be through certified mail or directly served directly. And you're telling me the sheriff is saying that he served me directly, which is untrue, and it's really confusing me. And I'm because I don't understand how a sheriff would lie about something like that, like you're saying. But he did not serve me. It was just rolled up on my doorstep. I came home one day, and there it was, just wrapped up in a rubber band.
Okay, so once you saw the papers, what actions did you take in order to prepare for court?
I was gonna show up. I was gonna show up to court. That was gonna be my plan of action. I was gonna show up, plead my case, show the judge my expenses and everything, and just go from there. But like I said, I mixed the days up.
Okay. So you mistakenly got the days wrong, and therefore you missed your court appointment. Is that correct?
Mm-hmm. Yes.
Okay. And have you had an opportunity to see the order that was defaulted against you? Do you have a copy of it? Did you get emailed or mailed a copy of the order that was entered against you?
Yes. That was just recently.
Correct. The hearing happened on August 2nd, and then it was mailed out.
I think I got that. I think I got that that paper maybe the week after, right after. Okay. Yes.
Okay.
I don't have it on me right now, though. That's why I was telling you earlier. I misplaced it.
That's okay. So in the order, what are the issues that, if any, that you are claiming are either fraudulent or mistaken, or that would change, that you believe would change if we had to do this all over again?
You mean what?
Yeah, that's a bad question. Yeah, it was a bad question. Let me go slower. The order found joint managing conservators between you and Miss Rodriguez, with Miss Rodriguez as the primary. You wouldn't be contesting that, is that correct?
No.
Okay. The order also found that that there is some visitation that's ordered, but your child is 17 and she kind of have a mind of her own, so I'm guessing you wouldn't be contesting that. Is that true?
True. Okay.
So the order claims that your income was a gross of $3,683. And is that something that you would be contesting, that your income is, and that's an average? That's
an average for every 3 months, or?
That's an average for the last 12 months.
How much?
$3,683 prior to anything being taken out of it.
I'm not understanding, like, the numbers. Like, how are you getting that numbers? Like, those numbers, like, is that like every check you're talking about? Is that the number you're saying I get paid?
No,
check.
this is prior to anything. It's okay. This is prior to any taxes or anything being taken out. Based off of your hourly wage and an average per week for 12 months of what was reported by your employer that you earned, that gross, before anything's taken out, you earn $3,683 per month.
I would have to look. I would have to see. I would have to look over the numbers myself and everything. But yeah. All I know is, like I explained to you.
Well, you got to explain it to the judge. So explain it.
Is she here? I mean, where is she? I don't see her.
Judge is on the screen.
Okay, yeah.
Can't tell.
Sorry, like, yeah, I'm talking to
I
him.
know you're not looking at me, but yeah, you should be able to tell.
Yeah, I need to see somebody to actually want to talk to him.
So, 1 second. On the bottom of your screen or somewhere, you should be able to press a button so that you can see all of the boxes instead of just the one who's talking.
All right.
You see that view? It says view and it's got a little grid on there.
Oh, yeah, I see it.
And you put all, or I can't remember what you put. What is it? Gallery. No, that's what we're in now. Put gallery.
Yeah, gallery.
Mm-hmm. Gallery. And then all of us show up in little boxes. Do you find the gallery in that drop down menu on view?
Maybe the upper right hand corner.
On the upper right hand corner, it says leave.
Okay, there's no sign in and then view.
Can you minimize the screen without making it go away? Just make it smaller so you can see all the edges?
Yeah.
You see the view? It says VIEW.
It's okay. I can't find it.
Do you see anybody except yourself?
I just see you now. And like I saw myself in that, and then I saw him. I was just seeing him, the person.
Well, then it's the speaker view. You have it on speaker where the speaker is the one that's talking.
Okay, I did it now.
Gallery. Okay, got it. Great.
So,
I didn't know what you meant. So, okay.
So, Mr. Gonzalez, yes, the judge is here, and we would like for you to tell your side of the event. So,
my side of the events of what?
Well,
basically.
I guess, yeah, I don't remember what the question was now. I
It was
apologize.
about the income and the gross versus, you know, he hadn't done the numbers yet to figure it out.
Yeah. Okay, yeah, like I'm not here to try to get out of any kind of child support or anything. Like I don't want to get out of it. The thing is, I was hoping that we can come to some kind of agreement to where it can be lowered every month just because of my living situation right now. My two daughters and everything, you know, the cost of living and all my bills. I was explaining to Corey earlier that just with this check alone, I only had like $100 to my name with all the bills that I have and, you know, living expenses. I don't get help from the mother. I don't get child support from her. I had two little girls, 6-year-old, 8-year-old. They're living with me full time. So, I mean, I don't get no government assistance either. I'm doing it all on my own. And I don't understand how, I mean, $600 and something extra a month, it's just really gonna put me and my daughters in a really bad situation. You know, it's been 17 years. I haven't seen my daughter. I don't even know who she is. It's been 17 years. This just came out of nowhere after 17 years. You know, I wasn't ready for this. I'm not prepared for this. And, you know, I was just asking to see, like I said, even though it has been 17 years, I'm not even trying to get out of the child support. Money's not really a concern to me. If I had it, I would give her all the money I had, but I don't have the money. That's the problem. And I don't want to lose what I have now with my two little girls, you know, because it's really going to put us in a bad spot.
Let me ask this, Mr. Calvano, did we know about the two other children and was he credited with them or is that?
Yes. May I screen share, Judge?
Sure.
Thank you. Okay, now appearing on the screen is a file stamped of August 9th, 2024, and it's entitled Order and Suit Affecting the Parent-Child Relationship. And this was the default order that was entered against you, Mr. Gonzalez, on August 2nd. And if we move down to one of the parts of contention, this is the findings on the concerning medical support, dental support, and child support. And it has your gross monthly resources. This is an average of 12 months based off of what was reported to the state of Texas and testified to by a child support officer of $3,683. And if you can see here, there was one child before the court, and there were two other children that were credited to you having. And then when we jump down to the findings page, your net resources then were $3,076 per month, and 16% was used, which is the percentage under the guidelines when there's one child on the case and two other children. So do you see that your two children were taken into account as per the guidelines?
I see the numbers.
Okay. Yeah. And what you're saying is the guidelines shouldn't apply to you because, and then if you can tell the judge why.
Okay, now that I'm seeing the numbers, actually, I just recently took a $2 pay cut also.
Okay.
I was forced to switch positions because the job I was working at, the position, it's getting taken over by robotics because our whole warehouse is being, upgraded to robotics and everything. So I'm currently actually in training right now for a new position, and I had to take a $2 pay cut, and that almost $4,000 a month just isn't correct. I've been making like way less than that recently.
Okay, so it's possibly that the child support would change a little bit if the order was overturned.
Yes.
Okay, and then
now that I'm seeing the numbers and you explained it to me, now I understand what you were saying with the almost $4,000 a month. Yeah.
Okay. I mean, it was 3,683, yeah. But yes, I got you.
Yeah.
Okay, and then another point of contention is the retroactive child support of $20,000 that was ordered against you. Is that correct?
Yes.
And did you pay anything towards child support or provide anything that can be accounted towards retroactive support?
I did not.
So what is your, I guess, defense as to why retroactive support should not be $20,000, which is actually less than what even 48 months would be based off of your guideline child support?
I'm not really the way you worded it, like defense.
Okay. Well, it was for lack of a better word.
It's more or less because Vanessa had told me she wanted nothing to do with me. She didn't want any money from me. She didn't even want my daughter to know me. And that was like an agreement that we had, kind of. She wanted me out of her life. She wanted me to sign her rights over. Like I said, she's told me plenty of times she wants nothing from me at all. My daughter doesn't need anything from her. She's well taken care of. She has a new daddy, and she pretty much kept pushing me out of her life and my daughter's life. After 17 years, all of a sudden, now that she's going to almost turn an adult, she wants to come and try to get me for this back child support that she never even wanted this whole time. She just wanted me gone. And it's like, I feel like now that my daughter's getting to that point where she's old enough to make her own decisions, now that I can actually be in my daughter's life without having to deal with Vanessa, it's like, kind of seems like she's trying to make it like, oh, well, I'm going to get him now for back child support. He's not going to get away with it. When in reality, that's what she wanted. She didn't want anything from me.
Okay.
Like I said, I don't even know my daughter. It's been 17 years. I haven't even seen her. The first time I saw her was in July, barely. This whole
Okay.
17 years, they were out of my life, both of them. I didn't hear a word from them. I didn't even ever even see them. So
Okay.
I'm just trying to figure out, like, where's the, you know, that's all it is. But if the judge, you know, and I do understand that is my daughter when it comes down to it. And I'm not trying to get out of anything. Like, I'm really not. If I had the money, I would give it to her. Like, I wish I did have the money. I really do, you know, because, you know, when it comes down to it, she is still my daughter.
Okay.
Okay.
This wasn't gonna be supposedly a substantive or merits hearing on the actual case. It was about whether I reopen it or not.
I thought
And-
that's why we were.
No, and Judge, the
No
Attorney
problem.
General, my apologies, Your Honor, the Attorney General wanted to go into a little bit of this for a reason. And, well, I can certainly bring it up in closing, I guess, but maybe right now is not an appropriate time. I don't have any further questions for Mr. Gonzalez.
I do have one follow-up question. To me, details matter, and you're here under oath. You're telling me that a deputy lied and filled out a form that he shouldn't have, or she, and that bothers me. And I've been on the bench a long time, and I rarely see that. However, it's not that it's never happened. I have seen some egregious cases where, like, ouch, I don't want to be the one to call the boss and say rat him out or anything. But on the other hand, if they're not doing their job, somebody needs to know, or I have to decide who I believe, you or the deputy's paperwork, and they're not here to defend themselves. So details matter to me. You said you just showed up one day and found it. Like, can you remember a little bit more than that? Like, you hadn't been home for a while, and where was it? How big is your porch? Was there any furniture there? Was it hidden? Was it right at the door? You couldn't miss it, or you missed it a few days in a row? Or, I mean, just tell me what your setup is and why you would have not seen it till that day, whatever day it was.
I don't know what day it was. I remember I had came back home from San Antonio. It had to have been in the afternoon. It was just rolled up there. It was wrapped in a rubber band, and it was in a plastic little baggie too, like some kind of plastic wrapping, not a baggie, but some kind of plastic wrapping. It was rolled up really nice, tight, in a rubber band. It was just left at my doorstep, and that's how I found it.
Was it like the door right in front of the door where it was blocking the door, or was there a step up where it was below the door and you could have opened the door and missed it? Or, I mean,
No,
what's your door like?
I couldn't have missed it. It was
Okay.
right by my door. It was right there on the ground, right in front of my door. Actually, I think it was, if I recall, I think it was actually like inside the door, like a little bit like standing up, like where
Is there a screen door in front of your
there's
locked
actually
door, or what?
Yeah, there's like one of them. I have one of them screens in front of my doors where you can like keep the flies out and stuff. You know what I'm saying? Like the ones you put up yourself, the ones that can open and close.
Okay.
Or whatever. I have one of those on my doorstep. All I could tell you, Your Honor, is that it was just placed on my doorstep, and that's how I found it. That's all I can tell you. I don't really.
Did you open it right away? Or you just brought it in and thought it was a flyer of some kind?
Nah, I opened it right away. I did. I opened it right away, and I saw what it was. And after that, I was gonna show up to court, and I was ready. I was ready to go. Like I said before, I was telling Corey, that Friday before, I had checked in the afternoon, late afternoon, because I thought court was on a Monday, that Monday after. But it turned out that when I did check to recheck, the papers, that court was actually that Friday that I checked, but it was in the morning. So, I honestly just mistaken the days. That was my main reason why I wanted to do the default, to appeal it, just so I can get my side of the story and maybe, go over the expenses and everything. But at the same time, also through technicality, everybody's telling me that I was not served correctly. If that was the case, that it was just left on the doorstep, that,
You
it
never
was,
saw a postcard that said, we're trying to find you, but you're not home, can call us, a business card, nothing like that?
no, ma'am. Not
And
that
how long would you have been, you don't remember, you were gone for San Antonio for days or weeks?
I wasn't gone for weeks, probably like a couple of days. I would go here and there.
Back and forth.
Yeah. But
Okay.
yeah, it was just left on my doorstep, and it's making me feel really uncomfortable too, just bringing this up, because I understand that's the sheriff and everything, and like me contesting it, like I don't want like any backlash or anything, like I feel like I'm gonna get like, what is the word? Like, just people coming at me because I'm over here just speaking my truth, saying that I really wasn't served correctly, and it's a sheriff. Like it can be an ugly situation, I think. But Your Honor, yes, it was just left at my doorstep.
And you didn't call the sheriff's office to complain about that at any point?
No, ma'am, I didn't, because at the time I was just going to show up to court, and I wasn't thinking about it at the time. I was just like, okay, it was left at my doorstep. I didn't care if it was, how I wasn't even sure. I just knew he left something at my doorstep, and I knew I had to be in court, and that's all that was really important to me at the time.
Okay, and did you tell anybody right away, or when did you start talking about it to anybody?
Yeah, I believe about a week later, I think, or a few days later, I might have told somebody. And, I was telling them my situation, and they were giving me a little bit of advice. But
okay, is there anything in your background that I should be concerned about, including arrests or convictions for fraud or what's the word? Mistaken, I don't know, identity, or just trying to fool people or lie about some things, or committing any kind of frauds
no,
at any time?
no, never.
You don't have any kind of criminal background, are you?
Yeah, you talking about recently or just all together in general? In 2008.
Well, how old are you? How old are you?
40.
Okay, since you were 18.
Yes, I do have a drug conviction that was in 2008. And I tried explaining that to you earlier when I had got out of jail, when I tried to see my daughter again. And did I tell you?
No, you didn't tell me.
I told
It was
Corey.
me.
Okay.
Yeah.
But 2008 is not quite 20 years, but it's what, 16 years or so?
Yeah, it's been my only offense, Your Honor. So.
Okay, you haven't had anything recently in the last 10 years?
Oh, no, nothing. Just working, taking care of my 2 little girls.
You've never been fired for fraud or embezzlement or anything nefarious like that?
Never, Your Honor.
Okay. Any other questions, Mr. Calvano, for Mr. Gonzalez?
No further questions for Mr. Gonzalez, Your Honor.
Mr. Rodriguez, let me, without talking to you yet, the state's going to call you. I'm not sure how you can input on his experience or not, but I'll let you. At this point, do you have any cross-examination for Mr. Gonzalez about his story or any questions about his story? If you want to ask them to him, you can't make statements. You can't call him names. You can't tell me your side yet. Just, do you have questions for him?
I do not.
Okay, that's fair. I just wanted to make sure you had your opportunity. Mr. Calvano, witnesses anymore?
Judge, I'll call Ms. Rodriguez really quick. It might not lead anywhere, but I'll give her an opportunity.
Sure.
Ms. Rodriguez, will you state your full name, please?
Vanessa Rodriguez.
And Ms. Rodriguez, when was the last time that you remember Mr. Gonzalez and the child saw each other?
Well, they met on July the 18th. That was the first time. Before that, she was 1.
Okay. And on July the 18th, did you and Mr. Gonzalez converse at all? Did you talk?
We did. It was more of arguing is pretty much what it was.
And at that time, did Mr. Gonzalez and you speak about any of the court proceedings?
Before we actually left, he had made a comment saying, what were we going to do legal wise? So, which made me assume that he was aware of the court date. So nothing else was spoken of that.
Okay, so just to be clear, Mr. Gonzalez didn't say, I'm not going to appear or anything like that to you?
No.
Okay. All right. I have no further questions to Ms. Rodriguez, Judge.
Mr. Gonzalez, do you have any cross-examination questions of Ms. Rodriguez?
I do not.
Okay. You would have no personal knowledge about the deputy in this case handing or not handing him the paperwork, Ms. Gonzalez, Ms. Rodriguez?
I do not.
Yeah. Okay. Any other evidence state would present?
No other evidence, Judge, just the closing.
You both testified, but let me follow up with you, Mr. Gonzalez. Do you have any paperwork, any other witnesses, any other kind of evidence you want to present before we wrap this up?
I do not, ma'am. I do not.
Okay, same question for you, Ms. Rodriguez.
No, ma'am.
Okay, Mr. Calvano.
Thank you, Your Honor. Your Honor, in this case, Mr. Gonzalez has requested essentially that the order be set aside, and liking that to either a motion for a new trial or a bill of review. In the same manner, Mr. Gonzalez then the burden shifts to him to prove that there's some reason why this order shouldn't apply. Mr. Gonzalez has cited that the citation is no good, that he wasn't served personally. The sheriff's citation was signed by the sheriff, filed with the court, has a proper date, had the notice with the proper court hearing date, other than the testimony of Mr. Gonzalez, there's no further evidence that has been presented that that citation is invalid. If we continue, if the citation based off of testimony alone is granted, I can see a slippery slope where every defaulted person that decides, not that Mr. Gonzalez did this, but that decides not to show up for a hearing and then doesn't like the results is going to say, hey, I wasn't served right. They didn't hand it to me, and the sheriff's not here to testify to that, and I have no evidence, but I want a new trial. So I think the fact that the burden shifts and that currently it's only testimony should not be enough evidence to open up a whole new case and throw away this default order. In addition, part of my questioning of Mr. Gonzalez about some more of the substantive issues in the default order was to show that even if the court decides that that order didn't give Mr. Gonzalez his just due, the chances that things are going to change from now, from this order to a new order, are as good as they wouldn't. There's no, by his own testimony, not going to be a contest on the conservatorship or the acknowledgement of paternity or the visitation. So all those issues are moot. The issues come down to the money. The evidence that was presented on the default is based off of guidelines. It took into account Mr. Gonzalez's children outside of this case. And it was not above guidelines or below guidelines. It was guideline child support based on the state of Texas family code. As far as the judgment against Mr. Gonzalez for retroactive support, I don't remember if it was based on 48 months or maybe even a couple months more than that because of the citation. But the bottom line is, if the judgment was based on 48 months, it could potentially be even more than $20,000 based on the income. If I remember correctly from the hearing, which I did, I believe Ms. Rodriguez rounded down from 23 or 24,000 down to 20,000, and then asked for a minimal payment of only $100 a month to pay down that retroactive support judgment. Now, yes, a retroactive support judgment is not guaranteed in any case. It is available and it's up to the judge's discretion. But the fact of the matter is Mr. Gonzalez testified himself that he has not paid anything and have not provided anything financially for the child. And so all of it is on the table. There is no credits that he's asking for. So based on the fact that it's even, I would say, likely that the order wouldn't change that much, then the state is asking, that the motion be denied. Now, one more response from on Mr. Gonzalez's claim that his income went down by $2. Even if it is reopened and he's offered to provide that evidence, doing a calculation, child support would be somewhere around $430 per month. If we take out $2 on average per hour, which is not substantially different from the $492 that was ordered. So with all of that, the state is requesting that the order be upheld and that the movement's motion for the order to be set aside is denied.
Okay, did you want to add any closing argument, Ms. Rodriguez?
No, I'm okay.
And did you want to make any final words, summary statements, sir, on trying to persuade me?
Yes, Your Honor. This Corey guy says that he's not supposed to be taking sides, but it seems like he's just all on Vanessa's side. He's not taking into consideration anything that I said. He really isn't. And it just isn't fair at all. Like I said, I have 2 kids. I have a life, going on, and the numbers are just incorrect. The ones that he's saying. I make about $1,000 every 2 weeks. There's no way I can afford a $600 and something with child support. It's going to leave my kids out on the streets, literally. And I'm hoping that you would take that into consideration and let me show the courts everything, all my bills that I have, my obligations, how much I get paid, and if I can show all of that, so we can adjust the numbers somewhat to where I could actually afford it, Your Honor. And if I could, I would work overtime to pay my child support, but I can't because I'm a single father. I need to make sure my kids get to school every day, all throughout the week. I need to be there for them when they get home. I need to put them to bed and everything. I need to do all that. I'm doing that all by myself. So it's going to be really difficult for me to put in extra hours during the week, especially if I don't have a babysitter. And I work overnight. So people, babysitters are really hard to find and they're really expensive. So it's like, if I even do that, it's like I'm going to be paying the babysitter all this extra money that I don't even have. And it's going to go to the babysitter, and the extra money I'm making, it's really not going to make a difference. So, Your Honor, I'm just hoping you would, you can understand my situation. Corey seems to not even care or understand. And
everybody's doing their job, and you can't fault them for that, Mr. Gonzalez. And I'm concerned about a deputy doing or not doing their job, and whether.
Yeah, that too.
Okay, anything else, sir?
I don't have any. I don't know what they expect me to do. They say I need to show burden of proof that the sheriff didn't serve me. I mean, he didn't. If anything, like I already told Corey, I'm going to have to file a complaint on this guy. I'm going to take the steps that I need to because he did not serve me personally, Your Honor. Just because he's a sheriff, I mean, it doesn't mean sheriffs don't lie. You know what I mean? Like, there's bad cops out there too. I mean, you can't say, oh, well, I have the burden of proof to prove it. Like, shouldn't he have the burden of proof to prove that he actually served me? If he's the one saying he served me personally and he's lying, because he didn't, Your Honor. It just seems like, it's like, oh, well, we're going to believe this guy because he has more credibility. That's what it seems like to me. And Your Honor, under oath, I'm telling you, I did not get served correctly with this citation. Corey said, the sheriff said he served me personally. He never did. This paper was just left on my doorstep.
Okay.
There's nothing else I can say to you, Your Honor.
In January, it'll be 30 years that I've been on the bench, and it's a long time. I've heard a hell of a lot of stories. And Mr. Calvano, the slippery slope argument, I think if anybody's going to do it, they'd be doing it already, because I've heard a lot of cases over the years. And honestly, I remember maybe less than a handful, 2, 3, maybe 5 or 6 tops in all those years of people coming in telling me something didn't happen like that. I can't tell you what I did or didn't do. Every case was different. But I do take it seriously, because we all have oaths to support when we take these public service jobs. So yes, the credibility is to tend to believe them, because if I don't, you upend the entire system. However, most people are credible. Most people do what they're supposed to do. Most people don't have these problems. There's another option. If they couldn't find him on the doorstep, easily ask for a Rule 106, where they could have served him by taping it to his door or leaving it rolled up on the front door. But as far as I can tell, this was not a substituted service kind of case. Mr. Calvano, that was never requested for you to file a motion for substituted service.
Absolutely not, Judge.
Yeah. Well, I kind of feel like sometimes we're the people's court, because we see the people without lawyers most of the time, and all I get is he said, she says. Here, there's no she said, because nobody was there except Mr. Gonzalez. And I've listened carefully, and I'm actually thinking, I believe he's credible. I don't believe he's lying about it. It hurts that I would even consider thinking that a deputy wouldn't do their job, but it's not like it's rampant. It's not like it's also unheard of. But I'm persuaded that it might end up in a slightly different outcome with testimony and numbers, financial numbers. So I am going to grant the motion to set aside. I'm going to find that Mr. Gonzalez is credible on the issue that he was not personally served. And I've got sworn testimony that has not been controverted. Now, you can do with that what you may, Mr. Calvano, but I'm persuaded I should give this man, it's child support court. Things matter. There's no relationship with the child, and I'm sure there's lots of reasons, and I'm sure I'll hear more about them later. But I'm going to give him his due shot to coming to court when, from what I heard, his story was, it sounded credible to me. So I'm going to go ahead and set aside the motion, and now we can give it a court date and put everybody on notice, and no questions asked that you don't come back, you get defaulted again, and things will probably happen the same again if you're not here, Mr. Gonzalez. So you have a court date, Mr. Calvano, that you would recommend?
Judge, I would recommend October 25th at 10:30. With all discovery documents due the week prior to that.
And by that, you mean any pay stubs or W-2s or tax returns? You want to put it specifically in there, or tell them specifically what you want? That was in your motion.
I will, Judge.
Okay. Yeah, they had a child support officer that came in and testified about the information they had for the past 12 months. So if you're saying it's different now, you need to bring the proof of your pay stubs or whatever it is that shows what your rate of pay is. So if that's your current information, Mr. Gonzalez, if you have anything from your employer that talks about your job and your change duties and the lower pay, something to support that. If you can get that from payroll or somebody, you should try that. Usually you ask for 6 months of stuff and 12 or 2 years of tax returns, or what exactly do you want, Mr. Calvano? So he's on notice.
Judge, I'll put in the order just 3 months because if it changed, it will have changed after what the Attorney General
Okay.
has for the state of Texas. So the change is what is important. And it will
So you
have your
want-
dates as well. So the last 3 months, I think, of pay stubs would be sufficient.
So you're talking about June, July, and August, or you're talking about July, August? Now we're in September. June.
Just the most recent 3 months, of paychecks. So
Okay.
yeah, it would be July, August, and September, I think would be fine.
Okay. So that's the pay stubs. Did you want any tax returns?
No, I don't think that's necessary. We have a reporting from the state. It's not a self-employment situation, so I think the numbers will stand as they do.
Okay. Do you have any court orders for custody or child support for your other children? Mr.
Yeah,
Gonzalez, or judges?
I have court orders.
Is it a state case? You went to the AG's office and they did it for you, or no?
No, I went to court.
Did you have a lawyer? Did you do it yourself,
Yeah,
or did the AG help?
I had a lawyer. I had a lawyer, ma'am.
So it was a private case. When what county is it in?
Kamal.
It is Comal. Bring your documents for whatever orders you have for those children. That would be important, whatever findings are in there, whatever your obligations are. Okay. And what else? Anything else, Mr. Calmano, including insurance information or not? Or some's moved, some's not, but
I believe Ms. Rodriguez has the child covered, and it's at a cost of $48, if I remember correct, which I think is probably as cheap as it gets. But if Mr. Gonzalez can prove, that he can carry for less, we can certainly address that as well.
did you understand that, Mr. Gonzalez? If you want to provide insurance and it costs you less than $48, then it's on you to bring the evidence of that. Otherwise, it looks like mom already has insurance at a $48 cost.
Yeah, I'm pretty sure I can add Mackenzie onto my insurance for free since I already have insurance for my other kids. I think if I add Mackenzie on there, it wouldn't bump up my insurance any.
Well, if it's going to be an issue, you bring proof of whatever. Don't just guess. Don't have me try to guess what your employer will or won't do and how much it costs. They should have summary sheets of whatever they do for families or plus children or whatever it is. Bring it. Okay. Anything else in the way of discovery, Mr. Calmano, that we've not already discussed?
No, Your Honor.
Okay. Then I'm resetting the case for October 25th at 10:30. You're both on notice to be back. If you're not here, either of you could be defaulted, which means we go forward without you. This is your only and your last chance, Mr. Gonzalez, to be back in court. You understand that?
I understand.
Now, the state's going to draft this order. They're going to route it to you for your electronic signature. You can choose to sign it. You can choose not to sign it. It doesn't matter to me. It's my order. I get to sign it, but we give you a courtesy to review and sign as well. If you don't, I expect the state to turn it in by next week, probably Friday or no later than the following Monday, with or without your signatures. If you both sign it and it's quick, I get it right away. If not, I wait a week. And if you haven't signed it, they turn it in to me without your signature. So be mindful of that. And then, but even if you don't sign it, you're still on legal notice. You're here in a courtroom with a judge under oath and on the record. You're being told about your court date. This will probably be the third or fifth time I've said the date, but October 25th at 10:30. Come back here. It's going to be not this Zoom ID, but the first one you entered. I came over here to have a hearing so that they could use the other one to conduct business, but at 10:30, you come in with all the other cases. We might stay there or we might bring you back here depending on what's going on that day, but it's the other ID number, not this one. And that'll all be in the order, but I'm trying to tell you ahead of time in case you don't look at the order or you lose the order or whatever else you think you want to do. But you're on legal notice. That doesn't change. So I need you back. And if you're not here, we go forward without you. And you can't be late, like hours late. It matters that you're on time. Okay, anything else, Mr. Calvano, admonitions or anything else you want to add about the details of the DocuSign?
Nothing further, Your Honor.
Okay, it's your one shot. Thank you, Ms. Rodriguez. It's not your fault. It's not anybody's fault, but that's the way the ball bounces today in this court.
All right,
Okay. Thank you. You're excused, and just check your emails maybe as early as this afternoon or by 5. See if it's there. If not, definitely start looking on Monday. Then that's That's it for this hearing. All you have to do is click the end meeting buttons. You're both done with court, and I'll wait till you exit the courtroom, and I'll turn off my records at that time.
Your Honor, may I say one? Can I ask one question, please?
Sure.
With this handing over all the court, all my information, like the check stubs and all that, like where would I send that to? Because everybody's telling me I was already trying to send it to these people, but everybody's telling me, oh, we can't help you with that. And every time I call somebody, they give me the runaround and they say, well, you got to talk to this person, that person. Like, I can't.
Okay.
I need like.
Let me, Mr. Calvano, you have that one page Zoom instructions that you usually attach to notices of virtual proceedings, something along those lines?
I do, Your Honor.
You can attach that because it gives you the email address for the state. It gives you the court's email address to send things to, although I do not look at them unless and until I have a contested hearing and it's admitted into evidence. So it can be there. Did you have you wanted a deadline date for the discovery so he knows to send it before a certain date? And you have the ability to review it, Mr. Calvano?
I do, 1 week prior to the court date.
Okay, well, let's say specifically the court date's on Friday the 25th, so by October 18th at 5 p.m.?
Correct.
October 18th, 5 p.m. is your deadline to turn it in. If you have it earlier, send it in, and maybe your very last paycheck right before whatever, bring it with you. I don't know if you get paid weekly or every 2 weeks or what your schedule is, but if you send something and there's one more thing that's even closer to court date, don't leave it behind. Just bring it with you or send it as quick as you can after you get it, even if it's after the 18th. What else was I going to say about that? And that, I guess that applies to you, Mr. Rodriguez, too. If you have anything you want to send in, you can send it by email. I was trying to remember what else. It'll have the Zoom ID on there. It'll have all sorts of things about Zoom and how to log on, but you already know how to do that. So that's just about the email addresses. They won't reject it. That's just a one way where you send it. They'll review it, and I guess Mr. Calvano will be looking for it anyway.
Okay.
I don't think I have any other instructions on that, Mr. Calvano. Did I leave anything out?
No, Judge.
Okay. But do turn it in. Oh, yes, I do remember. How does Ms. Rodriguez gets it? Because she'll be surprised, or I guess she sees it when I see it, if it's admitted, or I hate to give people's private information. The state will have it and you can share it with her on the day of court, or how do
There's no non-disclosures in this case, Judge. I do believe that the proper execution is that any documents sent to the Attorney General's office are also sent to Ms. Rodriguez.
Okay. Well, you heard that, Mr. Gonzalez. And is Ms. Rodriguez's email address going to be printed on this order?
I can, Your Honor, absolutely.
Mr. Rodriguez, do you want the information that way, or do you want to wait to have it shared in court with you?
I can have it emailed.
Okay. Then you have as your own lawyer, Mr. Gonzalez, you have the obligation to tell the other parties, that would be both Mr. Rodriguez and Mr. Calvano, about the information you intend to present in court and to send it on time. Got it?
So I need to send it to Vanessa too through email?
Yeah.
Okay, it's fine. Whatever.
Okay.
She'll see for herself. So
Okay. And Ms. Rodriguez, I just
money.
don't put him on social media. Don't do anything ugly or terrible that you by publishing his social security numbers and wages anywhere. I mean, this is court and it is serious, but I don't take it lightly that giving somebody's information like that. The state has confidentiality rules. I just don't want it to be used in ways they shouldn't be used. So that's why I'm even saying anything. I'm not accusing anybody of anything, but you're going to have it. So please be respectful of that. Okay. Anything else, Mr. Calvano?
Nothing further from the state, Your Honor.
Anything else, Mr. Rodriguez?
No, I'm okay.
Anything else, Mr. Gonzalez?
Yes, Judge. So sorry, man.
Go ahead. This is your one and only chance.
Sorry.
Let's wrap it up. What else?
All right. So what you want? So you want me to send everything that I'm going to send to Corey to Vanessa, like my check stubs, my court order, everything, bills, like all of that. You want me to send all that to Vanessa too? Like,
she's
wow.
entitled to it. Ms. Rodriguez, is there something you would want more than others, or things you don't care about, including a court order?
I don't need his bills. I mean, we all
Yeah.
have bills, so it seems like that seems like the excuse, but I don't need bills.
Do you need the court order too on his other children?
You know, I don't need anything. It's okay. Don't worry about it.
Okay, thank you.
Thank you.
But-
Ms. Lewis. Okay, then anything that's relevant will be put on the screen for me. And so that's where, you know, if you want to really look at it, that's where I get to look at it for the first time. So you won't be deprived at any point, but it might be best to handle it that way. Okay, thank you. Anything else, Mr. Gonzalez? That's it.
No, ma'am. Thank you, Judge.
Okay.
Thank you for
Okay,
being so
we'll
patient.
see you back here October 25th at 10:30 a.m. without fail of this year.
Okay, thank you so much.
Click the end meeting button so you're done.
Okay, thank you.